Well, hello. Welcome back. So if I believed in coincidences and superstition and all that nonsense, I'd say today's video is all my fault. So I'm going to give the stereotypical YouTuber apology. You guys, I messed up. It's all my fault. It's all my fault. I'm sorry. Okay, now that that's out of the way, so we're back with another episode of Delete Lawz, the DeCastro versus Abrams et al. And so why am I apologizing? Well, in yesterday's video, I mentioned a couple of things. So the second thing I mentioned, but I'll mention it here first, I I said specifically that it was 2:22 a.m. as I was close to ending the video, and I said if Delete Lawz posts anything today, it's going to be in the next couple hours. He tends to post very early in the morning. Well, I undersold it. He had posted within half an hour after that. And the other thing that basically I started yesterday discussing once again rules for thee, but not for me. And with Delete Lawz, if he's late filing a response, who cares? Deadlines are just suggestions, you know? If I'm late, well, I'll just, play dumb, ask the court for forgiveness, and, I'm pro se, so surely they can't hold it against me. See the Ironton lawsuit that at least twice he he res- he failed to respond to the motions to dismiss, and twice the judge said, okay, well, you get one more chance. It's nonsense. So, but if his foes are late, boy, oh boy, are deadlines strictly construed. You better not miss a deadline. And you know what? Even if a deadline has been extended, that original deadline is what the deadline really is. And I'm going to file motions for default judgment the even a day before the original deadline, even though it was extended by a month. So why do I bring this up? Well, because yesterday I was discussing how I was surprised not to see a motion for a default judgment against Google because February 1st was supposed to be the original deadline for Google to respond. But they had already been granted a 30-day extension. But I still expected him to ask because, if the past is any indication of the future, I mean, I'm a two finance degrees, so I realize the past is not an indication of the future. But if it is, it would suggest that he would have. But I wasn't paying attention to the entire docket because if we look back to 103, the motion for contempt, that was filed on January 16th. And generally, responsive pleadings are due 14 days after a motion, which 14 days after January 16th would have been January 30th. And yet the opposition, which was the subject of yesterday's video, came on February 1st, 2 days after January 30th. Now, it's excusable for me to not have noticed the deadline because, frankly, I'm a talking head on YouTube. I am an attorney, but I'm not Kate's attorney. So I don't put things in my calendar for this case. I just talk about them when they come up or when I think about something. So not even 30 minutes after I had finished recording yesterday's video, before it went live, it takes me a while to get it downloaded off of StreamYard and upload it onto YouTube and blah, blah, blah. So Delete Lawz actually came with what might be a winner of a motion for once in his life. And I'm disappointed in Benjamin Wish. I won't beat it. I won't beat around the bush. I'm disappointed in Benjamin Wish. But I don't think this is catastrophic. So let's take a look at the motion. So this is Delete Lawz, motion to strike defendant's late opposition to plaintiff's second motion for contempt. And that with the header up here, motion to strike defendant Catherine Peters' late opposition to plaintiff's second motion for contempt. Plaintiff Jose de Castro, plaintiff or I, hereby objects and moves this court to strike defendant Catherine Peter late opposition to plaintiff's second motion for contempt at ECF number 109. In support of this response, plaintiff submits a memorandum of law, which is fully incorporated herein. Background. On January 16th, 2023, Jose de Castro filed plaintiff's second motion for contempt at ECF number 103, asking for the court to bring judicial notice to this court of additional contempt by Peter. The motion was immediately served by the ECF system to Peter. Pursuant to Local Rule 7.1b2, Peter's opposition was due by January 30th, 2023, within 14 days after the motion is served. However, Peter filed the opposition on February 2nd, 2023, see ECF number 109, multiple days late. Last I looked, February 1st is not February 2nd. It's a small error, but an error just the same. Points and authorities. A. Peter's opposition was late. A party opposing a motion shall file an opposition within 14 days after the motion is served. The 14-day period is intended to include the period specified by the civil rules for mailing time and provide for a uniform period regardless of the use of the mails. Local Rule 7.1b2, with emphasis added. Here, the last stay within 14 days after the motion was served was January 30th, 2023. Peter filed the opposition on February 2nd, 2023. Maybe in Australia, but it was February 1st in Boston. Thus, Peter did not file the opposition within the permitted period. B. Rule 6b requires striking of the opposition. Rule 6b(1)b of the Federal Rules of Civil Procedure states, when an act may or must be done within a specified time, the court may, for good cause, extend the time. B, on motion made after the time has expired, if party failed to act because of excusable neglect. This is, at least this argument is going to hinge on what is excusable neglect. At least I think that's what it will. A district court may not consider a late filed response that falls short of the requirements of Rule 6b of the Federal Rules of Civil Procedure, Institute for Policy Studies versus USCIA, which is from the District of Columbia, District Court for the District of Columbia in 2007. So that's not First Circuit, that's not appellate, that's not binding on a court in Boston. But we'll see in a minute. Mr. Wish didn't bring any case law, I don't think. So C, Peter has not moved for a retroactive extension. In conformance with the plain language of Rule 6b(1)b, a court can grant retroactive extension of time only upon a motion. Lujan versus National Wildlife Federation from the Supreme Court in 1990, and Smith versus District of Columbia from the DC Circuit in 2005. In the absence of any motion for an extension, the trial court had no basis on which to exercise its discretion. I have a feeling that this motion was not written by Delete Lawz. This was written by one of his shadow lawyers who is still acting unethically by writing motions, ghostwriting motions for a pro se litigant. The rules are pro ses can have lawyers write motions, but the lawyer still has to sign them. Here, Peter has not moved for a retroactive extension of time to file the opposition. Incredibly, Peter does not even acknowledge that Peter tardily filed the opposition. Therefore, the opposition ought to be stricken. C, Peter has not shown excusable neglect. What constitutes excusable neglect is nebulous, but excusable neglect does not include ignorance of the rules or mistakes construing the rules. Pinkay versus Andrews, 9th Circuit, 2003. So 9th Circuit, once again, not binding, which quotes Pioneer Insurance Services versus Brunswick Associates Limited, a Supreme Court case from 1993. Here, Peter does not admit that it untimely filed the opposition, let alone offer an excuse. Thus, Peter has not shown excusable neglect. Rather, it seems that Peter simply forgot to file the opposition on time. Peter's belated opposition comes hours after Catherine Peter read in Discord about people pontificating way the court had not yet ruled on the motion for contempt. The chat on Discord appears to have triggered the belated opposition because Peter filed the opposition less than 24 hours after the chat. There are legions of cases finding no excusable neglect under similar circumstances. See Institute for Policy Studies. So which one was that? So that's District 4, the District of Columbia. You say there are legions of cases, yet you can't find one from either the First Circuit or the Massachusetts Federal Court. You have to bring persuasive instead of binding case law. If there are legions of cases, bring binding case law. Conclusion. For the foregoing reasons, Jose de Castro maybe the cat lawyer. I am not a cat. Jose de Castro requests this court to strike Peter's opposition to plaintiff's second motion for contempt. Additionally, if the opposition is not stricken, plaintiff asks for leave to file a reply to the opposition with documentary evidence, as the opposition appears to be full of perjured statements again. Okay. For starters, the opposition wasn't under oath, so where's the perjury? I mean, honestly, where's the perjury? You conclusively stating, well, it's perjury, doesn't make it perjury. Besides which, your motion for contempt was nothing but conclusory statements. There is no substance to it whatsoever. So that's what we had bright and early this morning from Delete Lawz. And then we got an underwhelming response from Benjamin Wish. Defendant Kate Peters' opposition to plaintiff's motion to strike. Defendant and plaintiff in counterclaim Kate Peter hereby opposes the motion to strike defendant Kate Peters' late opposition to plaintiff's second motion for contempt of plaintiff and defendant in counterclaim Jose Maria de Castro. Ms. Peter denies the allegations made in Mr. de Castro's motion to strike her opposition to plaintiff's second motion for contempt. I assume denies the allegations. I'm assuming that's concerning the allegations of perjured statements again, and this conjecture that Kate had forgotten, or Benjamin Wish had forgotten, and they were reminded by Discord. I'm assuming those are the allegations they're denying. The Office of Undersigned Counsel calendared the opposition to plaintiff's second motion for contempt based upon the notation in the docket entry, ECF number 103, we'll go look at that in just a minute, that the filing was modified on January 19th, 2023. As a result, the due date for the opposition was calendared as February 2nd, 2023, 14 days after January 19th, 2023. There is no prejudice to plaintiff from his receipt of the opposition 2 days after he originally filed the second motion for contempt. There is no material impact on plaintiff whatsoever, particularly where the parties await a decision on other pending motions, including Ms. Peters' motion to dismiss. Wherefore, Ms. Peter respectfully requests that this court deny Mr. de Castro's motion to strike defendant Catherine Peters' late opposition to plaintiff's second motion for contempt, and, to the extent necessary, permit an extension of 2 days to allow for the filing of the opposition on February 1st, 2023. Submitted by Kate Peter, signed Benjamin Wish. So I have thoughts. As to whether or not this is stricken, like I said earlier, it boils down to, is it excusable neglect? Mr. Wish does not make any mention of excusable neglect. That's the language used, isn't it? Yeah, excusable neglect. Benjamin Wish makes no mention of excusable neglect. If I'm writing this, I bring case law saying, well, of course this is excusable neglect. Someone in the office, possibly me, misread the docket because there's contradictory dates in the docket. Whether that's believable or not, it could be excusable neglect. But you've got to make the argument. You've got to bring some case law. But is it excusable neglect? I don't know. This is one of those things where Judge Burroughs could decide yes or no. And let's say that's appealed. That would be an abuse of discretion standard. So whatever her decision is would stand. So it could go either way. But let's look at the docket entry in question, 103. So we have here January 16th, plain as day. That's the date it was filed. But in the docket entry, we have second motion for contempt of court by Peter by Jose Maria de Castro. Main document 103 replaced on 1/19/2023 by Caitlin McManus. Additional dockets added on 1/19/2023. Number 1, Exhibit 1, McManus Caitlin. Modified on 1/19/2023 to separate exhibit from main document and add as an attachment. McManus Caitlin entered 1/16/2023. So it's been a couple of years since I've filed anything in federal court. So you look at the docket and you'd say, well, it's clear it was filed on January 16th. That's clear. But like I said, it's been a couple of years since I filed in federal court. I don't think I even have access to the email I used at the time, so I can't go back and look it up. But if Benjamin Wish or his paralegal or secretary or whoever's in charge of his calendar, they receive an email on January 19th saying this file was replaced on January 19th and put it in the calendar based on an email from the ECF system on January 19th, that might be excusable neglect. Once again, it's for Judge Burroughs to decide. But then we have to ask, Does it matter? Does it matter? Because as I've said, that contempt motion was hot garbage. It's a nothing burger. It's not even good for toilet paper. It's nonsense. So I don't know that it needed a response. I would have responded to it, but I don't know that it needed a response. But if you're going to respond, you have to do it on time. So what's going to happen? Well, I see two possibilities. The first is Judge Burroughs lets the motion stand. I mean, the reality is, let's take Benjamin Wish at his word that it was put in the calendar wrong because of the confusing docket entry and blah, blah, blah. So, yeah, looking at Rule 6B1B, if you can have an extension for good cause on motion made after the time has expired if the party failed to act because of excusable neglect. Well, the plain reading would say, well, you've got to make the motion in order to even make the late filing. But let's take Benjamin Wish at his word. And if the calendar was wrong because of excusable neglect, then why would you make the motion first? Serious. It's a serious question. If what Benjamin Wish says is the real reason, why would you do the motion first? Because you think you've done it on time. So, delete Lawz in his opposition to Google receiving an extension of time talks about a catch-22. If this is the case, this is a catch-22. So the court could recognize that, take this as the motion, as disappointing as it is, and say, yeah, whatever. And if she does, I'm sure she'll give delete Lawz his second request in his emergency motion and give him leave to file a reply to the opposition. So that could just give us more time for more hot garbage. And then deny the motion for contempt. The second option I see is she says, yeah, all right, I'm going to strike the opposition, but I'm denying the motion for contempt because it's hot garbage and it's not contempt. It didn't need a response. And so if I'm not taking Benjamin Wish at his word, and I think, you know what? It really was neglect on his part. I could see a scenario, like I've said, you can't take the past as an indication of what happens in the future. But we've seen how Judge Burroughs has treated past motions for contempt. She's denied several from both parties. She's denied them without response. So it very well could be that Benjamin Wish didn't respond because he thought, well, she's just going to reject it without response. And it got toward the deadline, and he's like, oh shit, she hasn't denied it. I better file a response. So that could be what happened. I don't know. Either way, I highly, highly, highly doubt that she's found in contempt, because it's not there. It's not contempt. But what does this all mean? So we know Kate has spent a ton of money on Benjamin Wish. And by Kate, I mean both her and her donors. So this disappointing motion, I'm 99% sure this was a freebie from Benjamin Wish. And the one we discussed yesterday, 109, the opposition, the late opposition, is going to be a freebie as well. So in the off chance, and I give it less than 1%, that she is actually found in contempt here and given a monetary sanction. If that happens, Benjamin Wish is paying that sanction. I mean, it sucks for him, but frankly, it will be cheaper and less hassle for him to pay it or knock it off Kate's bill or whatever, because if she's found in contempt, which, like I said, I highly doubt she is, very highly doubt, but if she is, it's not going to be a huge amount. And frankly, it will be cheaper for Benjamin Wish to pay that amount than it would be to deal with the bar complaint from Kate. That would be far more damaging for him. So that's where we are. It's let's see. Since I jinxed myself yesterday and stream less than half an hour before a new filing. All right, no updates. So with that, I think we're pretty much done for today. Short and sweet. I meant to do this at the beginning, but forgot once again. I'm getting extremely close to that magical 1,000 subscriber monetization. 56 subs short. I know there are at least 56 of you watching this who are not subbed, and I would greatly appreciate if you'd push me over that landmark. And, do all the other YouTubey things as well. Subscribe, like, share, subscribe, comment, do all those other wonderful things. And I'm sure I'll see you very soon for the next one. Thanks for joining me. Bye bye.